Welcome to the Deep Dive, your shortcut to being well-informed. We take the stack of information you have and pull out the most important knowledge and insights so you can get the key takeaways without getting lost in the details.
And in this deep dive, we're carrying on with our look at the Manual of Patent Examining Procedure, the MPEP. We're digging into Chapter 1800. That's the one all about the Patent Cooperation Treaty, or PCT.
Right, this is one part of our bigger series going through the MPEP section by section. Today, it's MPEP Section 1842, which is called Basic Flow Under the PCT.
Yeah, it's pretty much what it says on the tin. Think of it like a timeline, a roadmap. Our goal here is to walk you through the steps of an international patent application using the PCT system, from the very beginning right up to when it enters the national stage in different countries.
Okay, so we'll cover the main chronological steps, those key moments, and I guess really importantly, the deadlines involved, the strict time limits, right? All based on this specific section.
Exactly. The milestones and the ticking clock.
All right, so if we're mapping this out, where does the journey actually begin? If I've got an invention, maybe I've already filed somewhere, what's the starting point for the PCT clock?
It all hinges on the priority date. That's the foundational date. Almost every other deadline we'll talk about today ties back to this one date. It's really the anchor.
And that priority date, is that usually just the date I first filed an application for this invention, say, in my home country?
Typically, yes. It's the filing date of the earliest related application you filed. Could be a national one, could even be an earlier international one. MPEP Section 1842 points out, like you said, it governs most deadlines.
Why is it so critical?
Well, because that's the date you're claiming for novelty and inventive step purposes worldwide, essentially. It sets your place in line against prior art. Preserving it is key, and it ties back to, international agreements like the PCT itself and the Paris Convention, which the source mentions.
Okay, so the clock officially starts ticking from that priority date.
Yeah.
What's the first big action item within the PCT system itself based on that date?
So that takes us to what we can call phase one, filing the actual PCT international application. And there's a very important deadline here tied right back to that priority date.
Which is?
You generally have 12 months from your priority date to get that PCT international application filed. The source is clear on this time frame.
Just 12 months. Wow, okay. That feels pretty quick, actually, for something with international implications.
It is a tight window, yeah. And hitting that deadline is, well, non-negotiable if you want your PCT application to benefit from that earlier priority date. Miss it, and you lose that claim. You basically start fresh with the PCT filing date.
Got it. Okay. 12 months from priority to file the PCT application. Very clear first step. Once that's in, what happens next in this international phase?
Then we move into phase two, which is the international search. Once your PCT application is filed and checked, it gets sent off to what's called an International Searching Authority, or ISA.
An ISA. And their job is to?
Their job is to conduct a search for relevant prior art, existing documents, patents, articles, you name it, related to your invention, but on a global scale.
Ah, okay. So they're digging around to see if someone else already came up with something similar anywhere in the world that might affect my patent chances. What do I actually get from them and when?
You get two main things from the ISA. First, the International Search Report, the ISR. That lists the relevant prior art documents they found. Second, you get a written opinion, the WO.
A written opinion? What's that?
It's basically a preliminary non-binding assessment. It says whether your invention, as claimed in the application, appears to meet the key patentability criteria like novelty, inventive step, industrial applicability, based on the prior art found in the search.
So, like an early preview almost.
Sure.
Non-binding look at how strong the application seems.
Exactly, a first look. And there's a deadline for the ISA to get both the ISR and the WO back to you. The source mentions the specific PCT rules, 42 and 43Bs.
And that deadline is?
It's the later of two possible dates. Either 3 months after the ISA receives the search copy of your application, or 9 months measured from your priority date, whichever date comes later.
That whichever is later always trips me up a bit. Can you break that down? Why structure it like that?
Sure. Think about it. Let's say you used the full 12 months after your priority date to file the PCT application. By the time the ISA gets the search copy, that 9-month mark from priority might have already passed.
Right.
In that case, the rule gives the ISA 3 months from when they actually get the application copy. But if you filed your PCT application really early, say only 6 months after your priority date, the ISA might get the search copy before the 9-month mark arrives.
Ah, I see.
So in that scenario, they still have until that 9-month from priority date milestone to issue the report and opinion. It ensures a reasonable time frame for the ISA, but also sets an outer limit based on the priority date.
Okay, that makes sense. It provides flexibility depending on when you file the PCT app. So, search done, ISR and WO are in hand. What's the next major event on this PCT timeline according to Section 1842?
After the search comes phase 3, publication.
Publication. Okay, so this is when the details of my invention become public.
Exactly right. The source mentions Article 21 of the PCT here. Your international application gets published, usually online via WIPO, making it accessible to anyone.
And when does that happen? Is there a set time?
Yes, there's a very firm deadline for publication, 18 months from your priority date.
18 months. Okay, so priority date, then 12 months to file PCT, then publication at 18 months from priority.
You got it. That publication is a pretty significant step. Your application goes from confidential to public domain. This matters because it establishes prior art as of that date, and in some places, it might even trigger some provisional rights for you.
Interesting. Now, the MPEP section also mentions a couple of things applicants can do but don't have to do around this stage. Optional steps.
That's right. There are 2 main optional steps highlighted. The first one is called the Supplementary International Search, or SIS. The source points to Rule 45 Beavis for this.
Supplementary, like a second search. Why would I need that if the ISA already did one?
Well, it can be useful. The key thing about the SIS is that it's done by a different international searching authority, not the one that did your first search.
Ah, okay. Another set of eyes.
Exactly. The source suggests this can be particularly helpful in really complex tech fields, or maybe where there's a lot of specialized jargon in different languages. A different ISA, perhaps with different language expertise or database access, might uncover prior art the first one missed.
That makes sense. Is there a deadline for requesting this extra search?
Yes, you need to file the request for an access before 22 months from your priority date. And crucially, as we said, it has to be directed to an ISA different from the one that performed the main search.
Okay, 22 months for the optional supplementary search. What's the other optional step mentioned?
The other big one is filing a demand for international preliminary examination. This kicks off what's known as Chapter 2 of the PCT process. Chapter 1, with the filing and initial search, is mandatory for everyone. Chapter 2 is optional.
International preliminary examination. What's the purpose of that? Is it like getting a deeper dive before deciding on specific countries?
That's a good way to put it. If you file a demand, an International Preliminary Examining Authority, or IPEA, which might be the same authority as the ISA, or a different one, will conduct a more thorough examination based on the ISR and WO and any amendments or arguments you submit.
And what comes out of that?
You get an International Preliminary Report on Patentability under Chapter 2, often called the IPRP Chapter 2. This gives a more reasoned opinion on whether your claims seem to meet the patentability criteria. Novelty, inventive step, industrial applicability. It's more detailed than the initial written opinion.
Okay, potentially very useful for strategy. When do you have to decide whether you want to go down this Chapter 2 route? What's the deadline for filing the demand?
It's another one of those whichever is later deadlines. You need to file the demand either within 3 months from the date the ISR and WO were transmitted to you, or by 22 months from your priority date, whichever of those deadlines falls later.
Okay, 3 months from getting the search results, or 22 months from priority, whichever gives you more time. Now, does the timing within that window matter? The source mentions something strategic.
Yes, very much so. The source gives some really practical advice here. While you technically might have until the later of those dates, there's a strong strategic reason to file the demand earlier if you're going to do it. Ideally before the 19-month mark from your priority date.
Before 19 months. Why that specific point?
Filing the Chapter 2 demand by the 19-month mark generally ensures that the deadline for entering the national stage, which we'll get to next, remains at 30 months from the priority date in essentially all designated PCT countries that follow the standard rules.
Ah, I see. So if you wait longer, maybe closer to the 22-month deadline to file the demand.
Then some countries might have rules where the national stage deadline actually reverts to an earlier date if the demand wasn't filed by a certain point, like 19 months. So Filing the demand by 19 months locks in that full 30-month window pretty much everywhere, giving you maximum time and flexibility.
That's a really key strategic tip. So opting for Chapter 2 doesn't just give you a more detailed report, it can also safeguard your timeline for entering national phases.
Correct. It buys you time and insight.
Okay, so we've covered filing, the search, publication, and these optional supplementary search and preliminary examination steps.
Right.
What's the final major phase described in MPEP Section 1842? The point where things get country-specific.
That brings us to Phase 4, National Stage Entry. This is where your single international PCT application effectively branches out. You start the process in the individual national or regional patent offices where you actually want to pursue patent protection.
Right, so the unified international part is largely done. And now it's about dealing with, say, the U.S. Patent Office, the European Patent Office, Japan, China, wherever you've chosen.
Precisely. And entering the national stage involves meeting the specific requirements of each of those offices. Typically, this means formally requesting entry, submitting the application documents, often including a translation into the local language, which can be a big task, and, of course, paying the national fees.
Okay, makes sense. Translation and fees, the practicalities. What's the main deadline for getting all this done in most countries?
The big one, the primary deadline for national stage entry for the vast majority of PCT member states, especially those following the current standard under PCT Article 22.1, is 30 months from your priority date.
30 months. Okay, so that gives you 2.5 years from your very first filing to decide where in the world you want to pursue a patent, get translations done, and pay the fees. That seems like a reasonable amount of time.
It is. That 30-month window is one of the major advantages of the PCT system. It allows you to defer those significant costs and decisions until you have more information, like the search report, maybe the preliminary examination report, and a better sense of the commercial potential in different markets.
But I sense a but coming. You mentioned most countries. Does that 30-month deadline not apply everywhere?
Exactly. And this is a critical warning in the MPEP section. You absolutely cannot assume the 30-month deadline is universal.
No. What are the exceptions?
Well, the source points out that a few countries, it names Luxembourg and Tanzania as examples, have maintained older national laws or regional rules that set much earlier deadlines. For instance, some might still require national entry by 20 months from the priority date.
Wow, 20 months versus 30. That's a huge difference. You could completely miss the deadline in those places if you weren't aware.
Absolutely. Missing a national stage deadline usually means your application is considered withdrawn in that country. Game over there. So the source really stresses caution. You must check the specific requirements for each and every country or region you're interested in. Don't rely on a general rule.
Where would you check that?
Official resources are key. The WIPO website has time limit information, and the PCT Applicants Guide is another crucial resource. Consulting with local patent attorneys in those specific jurisdictions is also highly recommended.
Good advice. Always check the local rules. Now, what about applications where the applicant did opt for that Chapter 2 preliminary examination? Does filing the demand affect this national stage deadline?
It can, yeah. For applications that proceed under Chapter 2 because a demand was timely filed, the relevant rule is PCT Article 39. Now, this generally still provides that baseline 30-month deadline for national entry in most places.
It's usually the same 30 months.
Usually, but sometimes better. Some jurisdictions might actually offer an even longer period for national stage entry, specifically for applications that went through Chapter 2 examination. Again, though, the specifics depend entirely on the national law of that country. Checking is still vital, but Chapter 2 can sometimes buy you even more time in certain places.
Okay, well, so let me try and recap the basic flow. It starts with the priority date.
Yeah.
Then, crucially, you have 12 months from priority to file the PCT international application.
Right.
After filing, it goes for an international search, and you should get the search report and written opinion back by the later of 9 months from priority, or 3 months after the ISA gets the search copy.
Correct.
Then the application gets published at 18 months from priority.
Yep.
After that, you have optional steps: a supplementary search request due by 22 months, and/or demanding preliminary examination, also generally due by 22 months from priority, or 3 months after getting the ISRWO, whichever is later. And filing that demand before 19 months is strategically smart.
Exactly.
And finally, the big one, national stage entry, where you go into individual countries. The deadline is typically 30 months from priority, but you absolutely must check for earlier deadlines in specific countries. And Chapter 2 might sometimes extend that 30 months.
You've nailed it. That's the core timeline laid out in MPEP Section 1842. And the big takeaway from this section really is just how essential it is to understand this sequence and maybe even more importantly, to be super diligent about tracking and meeting these deadlines. It's the framework for using the PCT effectively.
It really is the basic flow, but yeah, it's packed with dates you just can't afford to miss. This section seems like the absolute starting point for understanding the PCT process timeline.
It's definitely foundational, the backbone of PCT strategy, really.
Well, that was an incredibly clear walkthrough of the PCT's basic timeline, according to MPEP Section 1842. Thanks for breaking down all those steps and deadlines for us.
My pleasure. Navigating the system really does start with getting this fundamental timeline down.
And before we forget, a huge thank you to Mike Shepard, our creative director. He's the one who organized this whole MPEP audio series.
Yeah, his work is invaluable in making this dense material more accessible.
Definitely. Now, we do need to include our standard disclaimer here. Just a reminder that this summary of the MPEP was put together using AI tools like ChatGPT and NotebookLM, and it might have errors or leave things out.
Right. It's really for general information and education. It's absolutely not legal advice, and it's no substitute for proper training or consulting the official source.
Exactly. For the final word, always go to the official MPEP itself, talk to a qualified instructor, or get advice from a registered patent practitioner.
Always the safest bet. Official sources and qualified professionals are key.
Absolutely. So as we wrap up this deep dive on the PCT timeline, here's something to maybe mull over. Consider this interesting balance. On one hand, you have this single international application operating on a largely harmonized global schedule during the international phase, letting you postpone those big, expensive national filing decisions for potentially 30 months.
Right, the deferral benefit.
But on the other hand, the system demands absolute precision when it comes to hitting those final national stage deadlines, which, as we saw, can actually differ quite a bit from country to country. So it offers this global reach and delayed commitment, but requires meticulous, localized diligence right at the end.
It's a fascinating blend of international harmonization and national sovereignty, isn't it?
It really is. A powerful system, but one that demands careful management every step of the way.
Indeed. Until next time on The Deep Dive.